Well, good morning. Welcome, everyone. Thank you so much for joining us today and happy Friday. If your week's been like my week, it's really nice that it's finally Friday. I'm Esther Barron. I'm part of the Donald Pritzker Entrepreneurship Law Center at Northwestern Pritzker School of Law. And that is an academic center at the law school. And we have lots of different classes and events and programming. And we have a clinic. And in the clinic, we represent entrepreneurs like yourselves. And we do lots of things like workshops and office hours like we're doing today. Um, I'm going to turn it over to Darren to introduce himself and tell you a little bit about what to expect for this morning, and then I'll be back in a minute.
Everyone. Thank you, Esther. I'm Darren Green. I'm very similar to Esther. I'm faculty in the Donald Pritzker Entrepreneurship Law Center at Northwestern Pritzker School of Law, teaching very similar classes, clinic and contracts and venture capital and things of that nature. Today, we're going to be talking about a topic that's near and dear to both of our hearts, entity formation and selection. Esther will start by talking about why we form these things and maybe when we form these things. And then I'll talk a little bit about what you might want to form. And we'll finish up. Esther will talk about a few kind of unique, kind of newer structures these days. So with that, and again, please do pass your questions along. We love questions. So feel free to put them in chat. We'll leave plenty of time at the end to answer those questions. So with no further ado, I'll let Esther take it away.
Thanks, Darren. And just to repeat what Darren said, please, you don't need to wait till the end. If you have a question, feel free to throw it in chat, but we will definitely save time at the end for questions. So entity selection, a really important topic, and probably one of the first legal issues that come up for many entrepreneurs and small businesses is what entity to select. And like Darren said, he's going to be talking about some really good options, but I'm going to start with some bad options. So if you don't actually make an affirmative choice and fill out the paperwork and make a decision and set up an entity, you still have a business association or an entity. And those are the default options. So if you are running a business on your own, you don't have any co-founders or partners, without doing anything further, you're what we would consider and be called a sole proprietorship. So if you're selling, clothing, or you're selling, have an online business where you're delivering food or anything like that, and you don't have any co-founders, you are automatically considered a sole proprietorship. And there's some consequences to that choice that I'm going to talk about in a minute. If you do have a co-founder or a partner, or you're working with someone else, again, by default, you're what is considered a general partnership. And so in Illinois, as many states, probably all states, when two or more people come together to run a business and share profits, they are, without even knowing what a general partnership is, they are by default creating and running a general partnership. And so, like I said, Darren's going to give some good options. I'm going to start with these, which we both think are pretty bad options. I'll start with what's good about sole proprietorships and general partnerships, and that's probably pretty obvious. They're super easy. You don't have to do anything really. You don't have to file anything separate. You're taxed just on your individual tax return. So from a sort of administrative standpoint, they're very straightforward and very easy. But why we don't like them and why we don't recommend them is that they also come with what we call unlimited personal liability. And that sounds scary. And guess what? It is scary. That means any obligations or debts or liabilities of the business become obligations, debts, and liabilities of the individual owner. So as a sole proprietor, it would be you. If you're running it with someone else and you have a general partnership, it would be the obligations of the general partners. And why general partnerships are even worse than sole proprietorships is, and again, this is pretty obvious, but there's more people creating liability. And so you're not only potentially liable personally for the liability or issues that you create and probably know about, you could also be on the hook for issues that you didn't create and maybe didn't even know about that your partner did. And there's joint and several liability, which means you could be on the hook for all of the liability. You could then go against your partner for their share. But from a third party perspective, they could come directly against you. So all of that said, I want to share a story with all of you. And sometimes I think giving an example can kind of help illustrate what the issues are and how they can be avoided. So this happened to me. Now it's probably been about a decade. I got a call from a friend of mine who is a partner at a law firm. So again, a sophisticated person who understands legal issues, but she doesn't practice in this area. And she said, Esther, I think my cousin's okay, but he called me and he was really upset. And I want to just run something by you so you could tell me that he's fine. I think he's fine, but he's really stressed out. And I just want you to, this isn't my area. And I figured you could probably make us both feel better. And I said, okay, sure. What happened? And she told me this story, which I'll tell you. Her cousin, who's a really smart person, was a consultant at a big consulting firm, had his MBA, and had moved out to a smaller city out west, and didn't know a lot of people, sort of started building his community and worked out at a local gym. And at the gym, he met a person who was a former athlete, and in that smaller town was kind of a pseudo celebrity in that area. And he became friendly with that former athlete. And that former athlete started training him at the gym. They started training together, and he paid the former athlete, and it was pretty great for him. He got to sort of brag to his colleagues that he was being trained by this, again, pseudo celebrity that a lot of people in the town heard of and thought was pretty terrific. That went on for a while. Nothing scary yet. And, some of his colleagues at work said, that's so cool that you get to train with that person. We would love that. And so he said to the former athlete, hey, if you want, I could, really get you a lot of clients and you could make a lot of money, and, you don't have to give me much of it. You could give me like a small referral fee, and, I could really get you a lot of clients. And the former athlete said, that would be terrific. I could really use the cash. So let's do that. So they started doing that. And he started referring his colleagues. People loved working out with him. He was a great trainer. And after a few months, the trainer, former athlete, pseudo celebrity, said to my friend's cousin, you know what? My schedule is full. Like, thanks. This is awesome. I love all the extra money. But please don't refer anyone else to me because I don't have any more time in my schedule, believe it or not. And the consultant, with his business mind and, loving making the extra money, said, gosh, what could we do? Like, I hate to just, there's so many people that would still like to work out with you. I don't want to leave money on the table. So he said, you know what if we got other trainers at the gym to use like if you create a training regimen or routine, and we had other trainers use that routine, and then people could still say they were kind of training with you because they were using your training method. And so it's still like bragging rights. And then we could still make more money. Like, it wouldn't be quite as much because we'd obviously have to pay the trainers, but we could still, skim some of that. And he said, great, if you think people would do that. So that's what they did. So then all these people who wanted to be able to say they were, training with this kind of famous guy were happy to be sort of pushed over to a different trainer, but using the same regimen. So this goes on and on. They actually created a website so that people could sign up or put in their, very simple website where you could just put in your email or phone number and someone would reach out to you. You couldn't pay over the website or anything like that. So this goes on for a while, and maybe 18 months, and they're both making a pretty good amount of extra money. And then one Saturday, the former athlete said, I'm going to pick you up for coffee. I have something I want to talk to you about. So he picks up my friend's cousin. They go to a coffee shop, and the former athlete says, well, I have some big news for you. I know you've really been the kind of business person behind this endeavor, and I appreciate it, but I'm also actually a very good business person, and I have a surprise for you. Over the last couple of weeks, I have signed a lease for us at a whole new gym, a huge facility. I've ordered new gym equipment. It's being delivered in a few weeks. And I have a loan at a bank under, for our business. And to his shock and surprise, my friend's cousin was not delighted. He was horrified. He had no interest in being part of this like new gym business that had all sorts of liability. They had, the lease was really expensive. He had ordered over $100,000 worth of equipment, I think closer to $200,000, and signed this loan with a bank. And so all of a sudden he started feeling really stressed out about whether he would have any liability. And this is when I got the phone call where my friend said, who's again a partner at a law firm, said, my cousin's fine, right? Because he didn't do any of that. He didn't even know that the athlete was doing any of those things. So he doesn't have any liability, right? And hopefully you're all thinking, no, not right. And the problem is, I was worried that what he had done is formed a general partnership with this athlete by coming together with another person for the purpose of making a profit and sharing profits. It doesn't have to be 50-50. It's just coming together to run a business and share profits. And the more I looked into it, the more I felt pretty convinced it was a general partnership. They even used the word partner on their website. It wasn't meant in a legal way, and I don't think they even had heard the term general partnership or thought that that's what they were doing, but they referred to each other as partners. So they had a general partnership, and her cousin was on the hook for all of the liability that this person had created. And because he had deeper pockets, the banks and the new gym landlord and the equipment owner, the manufacturing company, we're all going to come after him for the liability. And so first I had said to my friend said, well, how could they possibly have avoided this? Like what could they have done? And I said, well, if they had set up an entity, if they had set up, Darren's going to talk about corporations and LLCs, if they had set up one of those entities, then all of the liability would lie at the entity level and would not go pierce through to the individual owners like your cousin. Only the money they put in the business would be at issue and not the assets of your cousin or the athlete. And she said, oh, well, that's great news. You know what? Let's set up an LLC right now. And I said, well, we could certainly do that. But the problem is all of the liability that's created up until the time you set up the entity is still personal liability. You can't go back and fix it. It would be the liability of the business going forward, the LLC going forward, but you can't fix what's already happened. And she said, oh, this is terrible. The good news is we were able to negotiate the liability. We were able to work with the bank and with the manufacturing of the equipment owners and the gym, and we were able to get them out of a lot of the contracts. Her cousin still had to pay a bunch of money, and it was a really expensive lesson for him to learn. But it didn't bankrupt him, and we were able to get him a pretty good deal. Because I know some of you are out there probably worried about this poor guy. Don't be too worried. And it was also a long time ago. But it for me is a good lesson of this is a concept that really smart, sophisticated business people, even sometimes lawyers, miss. And so as you're thinking about starting a business, or maybe you're already running your business, this is a really important concept to think about. It's very easy to do. And the benefits from a liability perspective are huge. So again, something to think about early. Can't fix it once the liability is created, but a very easy, straightforward step to take. So now that I've scared you, I'm going to pass it over to Darren to make you all feel so much better and give you really good options of how you can avoid what happened to my friend's cousin.
Thank you, Esther. Thank you for that scary and informative story. As Esther suggested, there are solutions, ways to avoid that horrible state of affairs. So I'm going to talk a little about entities themselves. I'm going to start with just a few administrative things. We often hear that founders kind of put off forming an entity because it's too complicated or it's too expensive. There's sort of the fear of the unknown. If you've never formed one before, how do I do this thing? Does it take a long time and a lot of money? And the good news is actually forming an entity is very simple. It is not all that expensive compared to other expenses of starting a business. This one can be sort of minimal. You can form an entity in any state in the United States. Every state has the ability to form an entity within that state. And in fact, they all want you within that state because it can be revenues for the state. Um, what you do to form an entity is quite simple. There's a document, sometimes it's called Articles of Incorporation, sometimes it's called Certificate of Incorporation, Articles of Organization. The name doesn't matter. It depends on the type of entity you form and the state in which you're forming it. But it's usually a page or two. You usually provide 5 or 6 pieces of information. You submit the document to the Secretary of State of the state in which you're going to form. You can do that online in almost all states these days. And, anywhere from a couple of days to a week or so later, you get a stamped copy back from the state. Sometimes you get it electronically if that's how you filed, and you're an entity. That's it. Filing fees can range from $100, $125 up to, $250, $300 in more expensive states, but it's generally in that range. And that's all you do. There's other documents, depending on the entity you choose, that you might put in place. If the entity has more than one owner, you might have an agreement between you and the owner. That's not publicly filed. But to actually put the entity in place, it's that simple filing with the Secretary of State and paying that fee, which usually isn't too bad. So there's no reason to have a fear of forming an entity. It's a fairly simple thing to do. And it's not all that expensive. So that's the formation itself. I mentioned you can form an entity in any state. Any state would be happy to have you form there. So where should you form your entity? There's no right or wrong answers. We'll tell you this. If you're in Illinois, your business is based in Illinois, there's probably a good chance that Illinois makes perfect sense for you to use as a state to form your entity. Illinois has a very easy way to file online. They move pretty quickly. The fees are quite reasonable to form an entity in Illinois these days. And if you form in Illinois and you're based here, it kind of keeps things simple. You're in one state. You would maintain the entity in Illinois every year. You'd file an annual report and pay a little bit of money to maintain the entity. So any business based here, if you've got businesses that are based in Illinois, Illinois is usually a good choice. I'm going to mention another state only because you might hear of this state from time to time. It's somewhat unusual because it's not a state that's particularly close to here, and that's Delaware. You sometimes will hear about Delaware entities, Delaware corporations, or limited liability companies. Delaware's become a very popular state in which to form, but it really only makes sense if certain things are true. For example, let's say you have a business and you're going to raise lots and lots of money from institutional, professional type investors, like what they call venture capital investors, big funds that invest money. Those types of big professional investors sort of know the law in Delaware. They're comfortable with it. So sometimes they prefer entities that are formed in Delaware. But most businesses don't raise that type of money. Very few businesses raise money from those, millions of dollars from venture capital funds. So if you're one of the vast majority of businesses that isn't going to do that, Delaware may not make so much sense for you. And if you do form in Delaware, it can be a little more expensive because you have to maintain the entity in Delaware, and there still might be filings in Illinois you need to make. So I mentioned Delaware just in case you hear it out there. What about a Delaware entity? But again, for most types of businesses, Illinois probably is going to work just fine. Okay, so we know from Esther's talk why it's important to form an entity early to avoid those horrible risks that she described. We know it's not hard to form an entity, right? It's a simple filing with the Secretary of State, probably online, pay a small fee, and voila, you have an entity. We know where we can form. You can form in any state. Illinois, for an Illinois-based business, probably makes good sense for most Illinois-based businesses. But that leaves us with the biggest question, or one of the biggest questions, which is, what entity should we form? Maybe the trickiest of all the questions, because again, there's no single right answer that fits all types of businesses. But let's talk about some of the most popular options and some of the pros and cons of each of those options. So I'll start with the corporation. The corporation is an old structure. It goes way back. You've probably all heard of corporations. Some of you may have corporations that you formed. The standard corporation, when you form let's say you form a corporation in Illinois, the standard fallback form of corporation is what they call a C corporation, the letter C and then corporation. That's sort of the fallback, plain vanilla type of corporation. When you form your corporation, that's what you are. That's the default, unless you do certain other things to not be a C corporation. So let's start with C corporations. So what do C corporations do well? Well, one thing they do well is they address the issue that Esther talked about, liability protection. When you form a C corporation, it puts a shield around all of the founders of the business, the shareholders, right? Shareholders don't want to be personally liable for things that happen that relate to the business. And so the corporation puts that shield up. So if any third party gets upset, and these days third parties get upset all the time, we see lots and lots of litigation, more than we would like to see. They can go against the entity, the corporation, but they can't sue you personally. So that shield that you build around yourself, C corporations do that quite well. C corporations also make sense in other regards. They're fairly flexible. You can have any number of shareholders. Those shareholders can be located anywhere. They can be in Illinois, they can be in other states, they can be in other countries. You can have any type of investor in a C corporation. So let's say you were going to raise a little money from folks that you know or from other investors that you meet. Any type of investor is allowed to invest in a C corporation. So C corporations provide some nice flexibility around who can sort of be an owner of my business and who can invest in my business. They provide that nice shield of liability protection around the owners, the shareholders. So you might say, why doesn't everybody form a C corporation? It sounds like they do everything quite well. They do a lot of things quite well, and we're not going to go too deeply into taxes. We get very nervous when we hear the word taxes, but we do have to mention it a little bit because taxes are relevant when you form an entity. So there's a concept that you may have heard of, or maybe you haven't heard of, called double taxation. And without going into too much detail, when you form a C corporation, the IRS views that C corporation as like a fictional person. It's like a fake person you've created. And so when that C corporation makes money, just like the IRS would require you as an individual to pay taxes on the profits that you make in a year, so too does the IRS require that C corporation to pay taxes. If it makes money, it's got to pay taxes to the IRS. So that's all fine. But let's say that C corporation at the end of the year made lots of money and it's sitting on all that money. It doesn't need all that money to operate its business. You had a really good year. Well, so that C corporation could give some of those profits back to its owners, to its shareholders. You know, that's called a dividend. The IRS also taxes that dividend when you give money back to your shareholders. So if I make $1 in my corporation, I pay tax on that dollar as a C corporation. And then if I give what's left or some of it to my shareholders by declaring a dividend, they pay taxes. That's called double taxation. At a very general level, we don't like paying tax twice on the same dollar. We'd rather pay tax once on the same dollar. So C corporations can sometimes not be the most efficient structure for taxes. And I say sometimes because there's lots of details that can change the equation. And there's, if you work with tax advisors, there's strategies to minimize your taxes. But that double taxation does exist. So what do we do? How do we deal with this possibly inefficient tax structure around C corporations? Well, there's another type of corporation that you can form called an S corporation. So it's the letter S, then corporation. S corporations are nothing more than C corporations that decided they wanted to become something different. So when you form, let's say you formed into a C corporation in Illinois, there's a second filing you can make with the IRS called an S election. And by making that S election, which is like a 2-page form, a little more complicated than the form you file to form an entity, you're telling everybody that you want to be an S corporation. So what's an S corporation? An S corporation does a few things well, just like a C corporation. That liability shield that we talked about to protect against what Esther talked about, you get that same liability shield as a founder or shareholder in an S corporation. So it does that quite well. S corporations also don't have that double taxation issue. Again, without going into too much detail, in S corporations, they're often called disregarded entities. And what that means is the IRS disregards them, whereas the IRS pretends that a C corporation is a real person and taxes it. An IRS sort of turns its head away from an S corporation and says, I don't see you, I disregard you. So the S corporation doesn't have to pay tax to the IRS. Only the owners of an S corporation pay tax, single taxation, rather than the double taxation of a C corporation. So great. S corporations give us liability protection, and they can be more efficient from a tax perspective. Maybe we can pay less tax. So you might be saying, great, problem solved. S corporations do everything well. Not so fast, unfortunately. While all of those things are true, S corporations have a set of rules that come with them. And those rules can be problematic for some early stage or startup businesses. For example, S corporations have a limit on the number of shareholders you can have. Now, it's a high limit, 100. So for most startup businesses, you're not going to have more than 100 owners of your business. So maybe that one's not all that problematic. But there's lots of other rules. You can only have certain types of owners of your business. You can have individuals as shareholders in your business, but you can't have most other entities. So let's say you wanted to take in an investment and it was going to be an entity that was going to be investing in your business, like another corporation or an LLC or a partnership. You're by and large not allowed to have those types of shareholders in an S corporation. So it may not work for that reason. S corporations can only issue one type of stock, one class of stock. And again, without going too deep into the weeds, when you raise money, if you have investors that come in, often investors like a better type of stock than the founders have, and they call that preferred stock. You can't issue that better type of stock in an S corporation. So, and there's other rules, and we won't go into all of them right now, but there's all of these rules around an S corporation, which can make it a tricky structure for some types of early stage businesses. For some, it works quite well. And if you can meet all the rules, S corporation can work quite well. But many businesses can't meet all of those rules. They can't honor all of them. So what do? We've got the C corporation, which can work well, but maybe from a tax perspective, it's not great. We've got the S corporation, which takes care of the tax issue, also works well from a liability perspective, but has all these pesky rules that come along with it, which might not work. So where do we go from here? And where early stage businesses or entrepreneurs often go is to an entity which is a little bit newer than both the C corporation and the S corporation. It was invented like 50 years ago. And it's called the LLC, or limited liability company. You've probably heard that term because it's become quite popular in recent years. LLCs, or limited liability companies, really sort of take the best of both worlds. They take the best of the C corporation and they mix it with the best of the S corporation to create an entity which is supposed to give you all the benefits without most of the drawbacks. So what do you get with a limited liability company? Well, the first thing you get is that shield, that same shield that we keep talking about to protect the founders, the shareholders, from personal liability. LLCs do that quite well. LLCs also are disregarded entities, just like S corporations. So you can get maybe some better tax treatment within an LLC. Again, there's rules around it, but at a very general level, maybe you can pay less taxes in an LLC. But LLCs are also really flexible. They don't have all those rules that the S corporation had. So you can have any number of owners in an LLC. They can be located anywhere in the world. You can issue different types of equity. If you have investors, you can issue different types of equity. So LLCs give you the better taxation, the liability protection, and none of those rules around the owners of your business that we saw with the S corporation. So For that reason, limited liability companies have become a popular choice for a lot of early stage businesses. We see lots of businesses that Esther and I work with will be an LLC for all the reasons we talked about. Again, without going into too much detail, if you were going to raise that kind of money I talked about before, millions of dollars from big professional investors, sometimes they get a little nervous with LLCs or have other rules within their structure, which might prevent them from investing in an LLC. But that's like 1 in 1,000 businesses or more that raise that kind of money. So most businesses don't have to worry about that. So the LLC can be a good structure. We often get asked the question, okay, so what if I start with an LLC or a corporation, and I decide I made the wrong choice? It turns out that my circumstances require me to be a different type of entity. Am I stuck if I sort of formed the wrong one? And the good news is, by and large, you're not stuck. It's become much easier these days to change from one structure to another. There's a concept called statutory conversion, which used to not exist. It used to be a little harder to do this. But these days, in most states, you can file a fairly simple document with the Secretary of State and basically tell the Secretary of State, I was this entity, and now I want to be this other form of entity. You pay a small fee, and in most states, you can then migrate from the first structure to the second structure. So you want to try to choose the right structure coming out of the gate. It's easier, and you don't have to deal with the headache and a little bit of expense of changing. It's also a little easier to go from being an LLC to a corporation than it is from being a corporation to an LLC. It can be a little trickier to go from corporation to LLC as compared to LLC to corporation. But it can be done. You can go in all of these different directions. So if you're thinking about forming an entity, try to pick the right one coming out of the gate. Think about some of the things we talked about and talk to your advisors. But if it turns out a year later, you need to be a different entity, not a problem. You can become that type of entity. So those are the most popular entity structures, and I know we've covered them at a very high level. I'm going to turn it back over to Esther before we go to questions, because Esther's going to talk about a few unique structures that are at least worth knowing about in case they match what you're thinking of doing. So Esther, take it away.
So a lot of times you hear now when we meet with companies, they say that they're social entrepreneurs, right? That they have a social mission. And so it used to be that when we heard that, it would make us think of a not-for-profit, so a charitable organization. And so some of you may be thinking about starting a not-for-profit. There's lots of rules that go into that we're not really going to focus on today, unless you have questions. And when we get to Q&A, I'm happy to answer them. But there's some entities that say, some entrepreneurs that say, it's not that I want to be a not-for-profit. I want to make a profit. But I also have a social mission. I also consider myself a social entrepreneur. And that's a really important part of my business. And so we now have some options where you don't need to form a not-for-profit. You can still be a for-profit entity that really captures your social mission. And so the big options that we have today are, there's a low profit limited liability company, which is called an L3C. We have a public benefit corporation, and you can also have a B Corp. So the low profit limited liability company and the public benefit corporation, those are both options that are actual entities that you form at the state level. Not every state has that options. I think 30 states now have public benefit corporation options. The L3C is not very popular. I think that was created with the hope that the IRS would issue a letter saying that if you have an L3C, it's automatically approved for something called where foundations could give money and have it approved as almost an investment. That didn't happen, and we don't see L3Cs get used very often. Public benefit corporations are pretty popular, and the public benefit corporation, again, you form it at the state level, and you have a requirement to set forth what your social mission is. And in addition to setting forth what that mission is, you also have reporting requirements showing that some of the decisions you're making are to further your social mission. So you have both the requirement to increase profits for shareholders and to make the world better in some way that you've articulated in your articles of incorporation. A lot of times, social entrepreneurs, that really a fundamental reason why they're starting their business is for the social mission. This is a good option because it conveys to investors, customers, employees, co-founders that this is not just, something we're interested in. It's an integral part of why we're creating this business. Another option is the B Corp, where you have an entity, you've set up an entity, and you can apply to B Labs to get basically like a certification that you're a social entrepreneur, that you're doing something with a social mission. States that allow public benefit corporations, in order to get the B Lab status, you have to have set up as a public benefit corporation. If you set up in a state that doesn't have that option, you can have a different entity choice and apply to get the B Lab status. It's basically like a good housekeeping seal of approval. So it's not a separate entity. It's just, a certification that you're a mission-driven company. And we're happy to talk more about that in the Q&A if people are interested. But that's just to let, just a high level. If you're a social entrepreneur, your options are not just at this point setting up a not-for-profit corporation. You can be a for-profit entity that has the social mission intertwined with the sort of the fabric of the entity. And with that, we are going to open it up for questions.
And I'll start with a question that we've gotten a few times to kind of kick things off here. Let's say you're operating in Chicago, but you maybe are doing business in Indiana and doing business in Michigan, some of the surrounding states. Maybe you're opening a location there, or you have some sort of presence there. The question is, do we have to form in different states? Like, how does that work? And it can be sort of confusing. And the answer to that is no. So you only form in one state. So let's say you form in Illinois, that's where your business is based. And that's where you're sort of operating. Maybe you have an employee or two here, your co-founders are here in Chicago. If you were to go into Indiana, you don't sort of form a new entity in Indiana. You're always the same entity, or just one entity in whatever state you formed. In whatever state you form, you're allowed to do business in other states. There may be rules around taxes, right? If you open a location in Indiana, there may be a filing you would make in Indiana, or you might owe some taxes based on profits you make there. And again, we won't go too deeply into that. But your Illinois entity is, just as you as an individual are entitled to go work in different states if you wanted to, so too can your entity. It's allowed to go work in different states and perform services or have locations in different states. So while you might if you become big enough in a different state, there may be some filings you'll make with that state. You're not forming there. You're formed only in the one state, and that's it. You can only have the one entity unless you have like different businesses and you form different entities for each business. So I know that can be sort of confusing for a lot of founders, but whatever state you pick, that's your entity, and it can do business in different states.
I'll grab the next question. Someone asks, how many LLCs can one person own? I don't believe there's a limit on how many LLCs you can be a member in or an owner in, but what you may be getting at with that question is, when do you want to set up a new LLC, or sort of have one LLC where you're doing different types of business within the same LLC? A lot of times our clients will have an LLC and they'll do different things within that same LLC. If you think of huge companies like Procter & Gamble, think about how many different divisions they have. They don't set up a new company for every product that they're marketing. There's lots of reasons why you would set up a new entity, and I'll give you one big one. When you're trying to silo the liability of different types of businesses that you're running, then setting up a new entity is a good idea. If you're going to have different investors, like not the same people are going to own a particular business division, then of course setting up a separate entity makes more sense. But if you have an LLC and there's just maybe a couple of different things you want to do from the LLC, you can, if you don't have sort of countervailing reasons why that wouldn't make sense. But to your questions, you can certainly own many LLCs or be a member in many LLCs.
You, Esther. So I'll take the next one. I see. Can you talk about foreign and domestic corporations? So that can mean two things. So you can form. We talked about forming entities just in a state within the United States, right? Which is where the vast majority of entities, if you're here, if you're in the United States, where they'd be formed. There are foreign entities, in every country. There's different rules around forming entities. So if you were going to be operating in a different country, you're certainly free to form an entity there. The rules are different. Sometimes the structures are different. They're not called the same thing, and there may be structures there that don't exist here, and vice versa. So we won't go too deep into actual foreign corporations outside of the United States, but they do exist. The other thing you might have been asking about, sometimes when you form an entity in a different state, so I mentioned Delaware, for example. So let's say you form a Delaware corporation, because let's say you are going to raise money from a venture capital investor. You're that kind of business that's going to raise big money from investors. But you're based here in Illinois and you're operating here. So sometimes the Illinois Secretary of State will refer to that Delaware corporation that you started as a foreign corporation, even though it's not foreign in a traditional sense of the word. It's not outside of the United States. If any entity formed outside of Illinois, if we're in Illinois and talking about that corporation doing business here, we would refer to it as a foreign corporation versus a domestic corporation. If we were in Illinois and we formed an entity here, we would call that a domestic corporation. I mentioned before you can operate in different states. But let's take the foreign corporation question. Let's say I do have a Delaware corporation or an Indiana or a Michigan or whatever type of corporation, but I'm here in Illinois. This is where I'm based. I've hired a few people here, and this is really where I'm operating. I mentioned there may be a filing you might need to do in the state where you're operating. In Illinois, and in most states, there's a concept that's called becoming authorized to do business. All that really means is you're telling the Secretary of State of Illinois, look, I formed a foreign entity in Delaware or wherever it is, but I'm doing business here in Illinois. I'm operating here. So there's a filing you would make with the Secretary of State of Illinois to become authorized to do business here. You pay a small fee, and thereafter, if that's how things stayed, you stay a Delaware corporation and you stay kind of based in Illinois, you would make an annual filing both in Delaware to keep the entity alive in Delaware, and you'd make a filing in Illinois to continue to be authorized to do business here. So that's one of the things that sometimes happens when you're a foreign corporation or foreign LLC operating in a different state. It's a little bit more money when you form in a different state and you're operating somewhere else because you're making filings each year in both of those states and paying that small fee. So that's foreign and domestic entities. And with that, I'm going to turn it back over to Esther.
Terrific. Thanks, Darren. So I'm going to grab the public benefit corporation question. So someone asks in Q&A, Mario, thank you for your question. Can an LLC establish a public benefit corporation? And I think what you're asking is, can the LLC convert into a public benefit corporation? Unfortunately, the answer to that is no. At least in Illinois, there's no direct way for an LLC to become a public benefit corporation. Under Illinois law, a new corporation has to be created and the LLC merged into that corporation. And then at that time, the original LLC will cease to exist and the resulting company or the remaining company, the public benefit corporation, will be the company that moves forward. So there is a way to get there, but it's not a conversion. It's a merger. So you set up the public benefit corporation and you merge your LLC into the public benefit corporation. And there's some, rules around that. And you have to look at, your contracts and your members and get consent to do that. But that's how it would be done. It would be a merger into a newly formed public benefit corporation in Illinois.
So I'm going to take a question that we get a lot. It's a good question. So there are technology companies LegalZoom, Zen Business that you mentioned in this question. They can help you form your entity. So the question is it a good idea to use one of these types of companies to help with your formation, or maybe do it yourself? You can save a little bit of money if you do it yourself, right? You're not paying any third-party service provider a fee. These days, there are many, many options. LegalZoom was one of the early ones that you would hear about, but now there's dozens and dozens of companies. Sometimes even law firms, big law firms have these online document generators where you can actually create the documents to form certain types of entity online using the law firm's technology. Um, for most businesses, let's say you're starting a company and you're going to form an entity, and let's say the business is just you. You're the only owner, so you're going to be the only shareholder, or in an LLC, we call them members. That just means owner of the entity. And let's say it's just going to be you. So it's going to be a very simple structure, right? You don't have to worry about how do you work with your co-owner in your business, and how do you vote with them, and who's making decisions. It's just you. Sometimes these services can work perfectly fine in those situations. For a very kind of simple entity, that's all you need. They can kind of guide you through it. And for that type of entity, their fees tend to be a little lower. They're a little bit more reasonable. And they'll sort of give you some of the other documents you might want too. So, for example, if you use LegalZoom, they might help you create the articles of incorporation, a file with the Secretary of State. But then they may give you 5 or 6 other documents that most corporations would have in place, like bylaws, which you'll need, and some other documents, just so that you have a nice complete set of documents should you ever need them in the future. If, on the other hand, your structure is going to be a little more complicated. Let's say you've got 5 owners. So there's 5 of you coming together to form a business. So, 5 co-founders. And let's say you're all going to have different roles, and you're all going to have different ownership percentages. You're not each going to own 20% of your business. Let's say one of you is going to be the one to put a little bit of money in, right? Starting a business costs money, unfortunately. And so someone's got to pay those early bills. And let's say one of the 5 has agreed, you know what? I'm going to be the one to pay those early bills. In those situations, you might need a lawyer, right? In those situations, it probably behooves you, if you know someone who does this kind of law, you don't need to go to a big law firm for this type of work, but maybe a lawyer that works with startup businesses to help you navigate through what might be a little bit more complicated. Should you do it yourself? You certainly can. There's no requirement that you have a lawyer involved when you form an entity. There are certain things where lawyers do actually need to be involved, but this is not one of them. Individuals can complete that filing with the Secretary of State. Individuals can maybe find some of these other documents they're going to need and put them together. And again, there's no right or wrong answer. You have to be a little careful. You want to make sure that you've learned what needs to be done. There's tutorials that you can watch to sort of learn a little bit about this. And if your structure is a simple one, so not the 5 owners, one person putting in money, different ownership percentages, but you're going to be the only owner of the business, you might be able to do it by yourself. We've seen lots of founders do that. But you just want to make sure that you have sort of learned what you need to do. And if you're a little bit less comfortable, maybe work with one of the services, or find a lawyer that's used to working with entrepreneurs, a lawyer that's not going to charge you a fortune for the services. That'll turn it back over to Esther.
Another question in the Q&A is, the new law that states that all LLCs and also corporations must disclose shareholders. How can you have liability protection if you're now revealing the shareholders? So this is a great question, and I want to make sure I was clear when I talked about the liability. So I think what you're referring to is the new Corporate Transparency Act that passed last January that requires entities to disclose a bunch of information, including who the owners are. Disclosure is required, but that doesn't create liability. The liability is different than just knowing who the owners are, knowing who maybe you don't love that you have to allow people to know who your shareholders are and your owners are. That is required, but that doesn't create liability. If you set up an entity, you still have the limited liability for the owners. which means that if someone were suing your business for a breach of contract, for product liability, for a tort, for whatever it is, they're suing the company. And if they win, it's the money and the assets at the company level in the entity that are at risk, as opposed to your individual bank accounts and homes and, you know, securities accounts. These are not at risk. So yes, you're right that there's this disclosure rule, so it's not anonymous. But if you set up the entity, you do have the advantage of the limited liability protection. So separate sort of disclosure from liability. Think of those are two very different things. So hopefully that answers your question. Thank you.
And I see a question here, again, about creating multiple LLCs and, when might that make sense? And Esther started to talk about this a little bit before. There's a question, if I'm doing a real estate, if you're doing Airbnb, right, which is a popular thing to do these days, but I have construction or rehab workers, maybe I've got separate businesses. Should I have multiple LLCs? Is there a reason to have more than one? We've been talking primarily about that single entity for your business. Most businesses have that single entity. Again, most early stage businesses, one entity works quite well. But there are situations. So let's say you have you're a serial entrepreneur. You're somebody that likes to do lots of different things. And you've got like two different businesses, one in real estate. So maybe you are renting out an Airbnb. And then you've got another business which isn't related to that. It's you're selling clothing online. I'm not very creative, so I'm just making things up. You could operate both of those businesses out of the same LLC. So I could form an LLC. That LLC could, own my property, and maybe the Airbnb is done out of the LLC. And I could sort of sell clothing. That business can be owned by the LLC. So that's very simple. I only have one entity that I have to maintain, which is a nice thing. The problem is if I operate very different businesses out of the same entity, let's say I have a problem in one of the businesses, and by problem, I mean I get sued. I do something, some third party is upset, and they sue the entity. Well, if they sue the entity, and the entity owns my Airbnb business, and the entity owns my clothing business, that whoever the plaintiff is, whoever sued me, if they win, they can go after both of those sets of assets because those assets are owned by the same fictional person, the LLC. They could reach my clothing business and maybe put me out of business or, take some of that inventory. Who knows what would happen? So when you have two very different businesses where there could be different liabilities that arise within each of them, sometimes you will separate out and create one LLC for the Airbnb business and one LLC for the clothing business. And the idea would be, now if I have a problem on the Airbnb side, for example, and somebody sues, they can only sue the Airbnb entity because my clothing entity never signed a contract with them. It has nothing to do with them. It's a separate person in essence. So I'm protecting those assets by putting them separate from the assets in my Airbnb LLC. So, the benefits of doing that are you might be able to avoid liability reaching other business assets of yours. But there's a downside. It gets more complicated, right? If I form two LLCs, and look, sometimes founders will create like a holding company and then drop like subsidiary LLCs or corporations below. You can get very complicated with these structures. At a certain point, you're really going to need advisors who understand those structures, like a tax advisor who knows how to deal with the taxes of these multiple entities that are maybe related to each other in one way or another. You might need more help from a lawyer to put a proper structure in place if your goal is to avoid liability expanding to other business assets. You're going to be filing multiple fees in the state where you form to maintain these entities. So while it can make sense, and sometimes it makes good sense to do that, it's a little more complicated and can be a little more expensive to sort of maintain over time. So that's something you want to think about. Is it worth it for me? Am I really mixing liabilities together in this entity, or do I need sort of separate entities? So hopefully that answers your question.
And we're almost out of time. I'm going to squeeze one more question in. For a not-for-profit or social entrepreneur, what's a good resource? Well, there's a really good resource actually on the Illinois Secretary of State website. That's a kind of a booklet that you can download. This is for not-for-profits, and it walks you through the steps of what you need to do. So it's at a very high level. You're setting up a not-for-profit corporation. Um, there's the form that you submit. It tells you the requirements of like that you need 3 directors in Illinois. And then if you want tax exempt status, so that's at the state level, you would form the Illinois not-for-profit corporation. There's also guidelines and resources at the IRS website, irs.gov, that walk you through how you apply for tax exempt status. That's the 501c3. It's pretty complicated, but there are really good resources both on the Illinois Secretary of State website and the irs.gov website. With that, before we absolutely run out of time, I did want to let all of you know, Darren and I also work with clients, with our students in the clinic. We are mid-semester right now, so we're not taking any new clients, but the next time we'll be taking new clients is in January. So if there's a project you think you might need help with and you want to apply to work with the clinic, it's pretty fun. You get to work with law students who are amazing, and we do not charge for our legal services. If there's out-of-pocket expenses, obviously you'd be responsible. But it's a class, so it's not something we charge for. I'm going to put the application in chat. Hopefully everyone can see that. And with that, we want to thank all of you for such engaging, excellent questions. This was a lot of fun for us. We really appreciate the interest and the time that you spent with us.
And I'll just reiterate what Esther said. Please do apply to the clinic if you've got some legal needs. We love working with clients we meet in these presentations. And thank you all for your wonderful questions. It makes it fun for us to get so many good ones. And have a good Friday.
Bye, everybody.
Thank you for today's presentation. If you are a part of the BACP Entrepreneur Certificate Program, you will automatically receive credit. In order to receive a certificate, you must enroll in the program. To learn more about our upcoming webinars, please visit chicago.gov/BACP webinar. Thank you and have a great weekend.